Pursuant to Executive Order 7B, Governor Lamont, we're conducting this meeting via teleconference only. There are people that are on call-in, and there are people that are on video as well. I would ask anyone who doesn't have something to speak about at that moment to mute yourselves. I will give everyone an opportunity when we get into the public hearing session, and I will open it up and you have an opportunity to speak. Obviously, I will introduce each particular matter and the applicant or his or her agent. Once I give you the go-ahead, you can start your presentation. For the people, the attorneys that have been on this, you're familiar with this. For the people that are not, I will explain a little bit in detail of how we're going to proceed. But it is no different than the Zoom meetings that you've been on. You just need to be patient because we have a lot of people participating, both by video. We have people that you want to make sure hear your presentation and hear your comments, and that's the board members. So before we get into the call and my instructions, I have some preliminary matters on the executive session. The first is approval of the minutes of June 11, 2020. Entertain a motion to approve. I'd ask one of my board members to so move.
So moved. Terry Keegan.
Thank you, Terry. Is there a second?
Jane seconds.
Thank you, Jane. Okay, any discussion on the minutes? I know we sent some corrections to Josephine before this, but are there any other corrections which are needed? Okay, hearing none, let's bring it to a vote. Jane, what say you?
Yes.
Terry?
Yes.
Katie? Yes or no? You're muted.
I'll unmute her.
Yes.
Okay. All right, Faith?
Yes.
Thank you. Next item is approval of secretary fees. Entertain a motion to approve.
So moved.
That was Jane. Thank you, Jane. Is there a second?
Second. Terry Keegan.
Terry. Discussion? Hearing none, bring it to a vote. Jane, what is your vote?
Yes.
Terry?
Yes.
Faith? What is your vote, Faith? Oh, she's circling. Faith, what is your vote? We lost you for a second.
Yes,
Okay.
I'm actually,
And yes? Okay,
Yes.
unanimous. That's been approved. Now I'll call to order a zoning board of appeals hearing July 9, 2020. As previously indicated, in light of COVID-19 and pursuant to Governor Lamont's Executive Order 7B, we are conducting this hearing via teleconference. We have people on video that have been invited for that. It's usually the applicants and some opposition. And we have people that are on call in as well. The way it's going to go is I'm going to be calling each matter. Have the call. It's the docket, which you all have a copy of. I'll give the property address and description of what they're seeking. Then I will ask the applicant or his or her agent to begin their presentation. Please note that things have been mailed and emailed in, and the board has received a copy of your application, and Mr. Decker has sent us copies of information that have been submitted, including some submittals for the petitions that were signed, which is great. If you have something else that you need, and if you know how to do a share screen, that would be perfect. Or you have to email it last minute to Mr. Decker, but it might be difficult to get that up. But everything has been on the town website, so, and if you submitted it, we have it and we've already reviewed it. I'd like the applicant to give their entire presentation, and then I will invite the board to ask questions of that applicant, and we'll try to go in order. I'll probably give a raise of the hand, a flag me down that they have a question, and then you'll have to answer each of the questions by the board member if there are any questions. After that, I will invite anyone who's in favor of the application to then speak. They will have an opportunity to speak in favor of it. After anyone that's speaking in favor, if there are anyone, then I will invite anyone who opposes it to speak. And they will have an opportunity to speak and may have questions from the board as well. Following any opposition, if there is opposition, I will invite the applicant to address the opposition. That is a time for you to address the opposition only. It's not a time to restate your application. We're doing this by video, but we're also recording it. And it's very important that because of those two things, we take our time and we be patient and you wait to be called on. I will give plenty of time for people to make sure that they let us know that they have something to say, whether they're in favor or against each application. Anyone who does speak, please give your name and address so we know who is speaking. We might not be able to see you. It may be a call, and so it's important that we know your name and your address, and then you can make your comments. Please make sure your comments are on the point of this application and what this board role is. Any comments that are too far off the point, I reserve my right as chairman to restrict your comments at any time. After the public hearing is complete, what we'll do is we will either take a short break or most likely go back into an executive working session. At that time, we will be discussing each matter that goes forward today. And we will be discussing it and voting on it, on whether a variance as requested has been approved or denied. You are welcome to stay during that. There is a discussion. I would want everyone to be muted except for our board members. It's not time for anyone to be speaking other than the board members in discussion. It's going to be treated no different than if we were in the conference room at town hall. No one else is allowed to speak during that. You're just invited to listen in and observe because we're discussing your application. And remember, you will need at least 4 of the 5 members on this board to vote in favor of your application for your variance request to be granted. If an application for a waiver is granted, it will not be valid until it's recorded. Therefore, you must bring or send a check in the amount of $60 made out to the town of Fairfield and bring it or send it to zoning office Wednesday or later following the meeting for proper recording. Any waiver involving construction, whether it's for a new dwelling addition or an alteration, will require an as-built prior to an issuance of a certificate of zoning compliance and a certificate of occupancy. And ladies and gentlemen, if you cannot stay and you have to leave us after your application, that is also fine. And if you want to find out what happened, you can call the zoning office tomorrow to find out what happened on your particular matter. Okay, so the first matter that we have, and it's on our continued docket, and that is continued docket number 12. And this is 101 Henderson Road, map 229, parcel 89, petition of SUGS LLC for a variance of the zoning regulations, section 5.1.1, to reduce the required lot area and lot square from 9,375 square feet and 75 feet, proposing 7,500 square feet and 50 feet, and section 2.7 to reduce the street frontage from 75 feet, proposing 50 feet. Permission to confirm the legal status of a vacant piece of land as a building lot for a single-family dwelling premises A zone. And this is Attorney Fitzpatrick presenting this, correct?
Yes, Mr. Chairman. Can you hear me?
Yes, I can. Thank you.
Great, thank you. Mr. Chairman, members of the board, for the record, my name is Bill Fitzpatrick. I'm an attorney in Fairfield with the law firm of Fitzpatrick, Cray, and Bologna. They have offices at 1735 Post Road. I'm here this afternoon representing SUGS LLC, the owner of property known as 101 Henderson Road. This property is a vacant lot measuring 50 feet wide by 150 feet deep for a total square footage of 7,500 square feet. This parcel accommodates a 50-foot minimum square and has 50 feet of frontage on Henderson Road. Zoning classification for this property is Residence A. Residence A has a minimum lot area requirement of 9,375 square feet, further requires a minimum square of 75 feet, and a minimum frontage of 75 feet. Property to the east at 91 Henderson Road is owned by the same entity, but each of these parcels has its own address, and each has been consistently recognized by the Town of Fairfield's Assessors Department as a separate parcel. The two parcels were purchased separately by the Carroll family. The house lot in 1924 and the vacant lot, 101 Henderson Road, in 1926. There is a vision appraisal printout for each of the properties in your information packet. The history of this property is that it was originally created by the creation of a map entitled Plan of Lots of Riverside Park. This plan is dated July 1922, and it shows the parcel in question, a vacant lot as Lot 16, and the property to the east, which presently contains a single-family home, as Lot 15. The configuration of the parcels on that map, the 1922 map, is the same, 50 feet wide by 150 feet deep, as the configuration of the two lots today. That plan, which was submitted with the application, includes the signature of the chair of the Town Plan Commission adopting the plan on December 13, 1922. Zoning regulations were adopted by the Town of Fairfield on August 26, 1925, after the date of the Riverside Park Plan and after the date of the adoption of the plan by the Town Plan Commission. Connecticut General Statutes 8-26A provides legal protection to parcels of property contained in a subdivision plan. This statute provides protection from the enactment of zoning regulations which would render the lot non-conforming. The language of that statute refers to a subdivision plan, and that statute has been interpreted to apply only to parcels contained on an approved subdivision plan. In Fairfield, the subdivision regs, which set forth the criteria for the approval of the subdivision, were adopted by the P&Z on March 8, 1948. Therefore, at the time the Riverside Park map was put together, and at the time the Town Plan Commission approved it, there were no subdivision regs, and therefore, under the strict construction of 8-26A, there is no subdivision approval. As a result, the lot at 101 Henderson, despite having been in this configuration since 1922, is not legally protected and instead requires a variance. I have referenced this variance as a technical variance because if the subdivision regs had existed in 1922, this lot would be legally protected. The regs were not adopted until later, so this variance application is required in order to permit the use of the lot for the purpose for which it was acquired. As a result, the applicant is before this board requesting the variance of section 5.1.1 of the zoning regulations to reduce the required lot area from 9,375 square feet to 7,500 square feet, to reduce the required square from 75 feet to 50 feet, and a variance of 2.7 to reduce the required lot frontage from 75 feet to 50 feet in order to confirm the status of the property as a valid building lot. The legal test for the granting of variance, as you've heard from me in the past, is set forth in the 1998 Connecticut Supreme Court case of Adolphson versus ZBA, 207 Connecticut 703, which states, regarding hardship under general statutes, section 8-6, parens 3 and parens, the local zoning board may grant a variance where two basic conditions are met. One, the variance is shown not to affect substantially the comprehensive zoning plan. And two, adherence to the strict letter of the zoning regulations is shown to cause unusual hardship unnecessary to the carrying out the general purpose of the zoning plan, end quote. First part of the test, substantial effect on the comprehensive zoning plan is satisfied here where the proposed use, a single family lot, is certainly a permitted use in the Residence A zone. The second part of the test, adherence to the strict letter of the zoning regulations, is shown to cause unusual hardship unnecessary, excuse me, to the carrying out of the purpose of the zoning plan, is satisfied here, I would submit, by several factors. First, the clear intent of the owner of 901 and 101 Henderson Road from the original purchase of these properties in separate deeds 2 years apart was to build on one parcel and retain one parcel as a building lot. If you look at the data accumulation plan, which was submitted as part of the application, the house and the separate standalone garage are located completely on lot 15, which is 91 Henderson Road. Similarly, the property to the west, the subject parcel 101 Henderson, has been kept vacant. In addition, the legal status of the two parcels has always been as two separate parcels, as confirmed by the fact they were purchased separately, and it's confirmed by the legal description of the two parcels set forth in the Certificate of Devise of Margaret A. Carroll, which I submitted as part of the application. In addition, the Town of Fairfield Assessor's Office has consistently taxed the two parcels separately and has assessed and taxed the vacant land as a building lot. Given COVID-19, it's difficult to access town halls for the purposes of research, but we did include, in addition to the vision appraisal data sheets, some field cards for the property which show 101 Henderson being taxed as a building lot with a valuation in excess of $200,000, and an earlier field card which shows, again, a 1980 field card shows the property again as a separate parcel and valued as a residential lot, not as excess land. Lastly, I think it's important for the board to note that the parcel at 101 Henderson is completely consistent with lots containing single-family homes up and down Henderson Road. The houses on Henderson Road, by and large, are almost all, with the exception of the two lots next to Mill River and perhaps one or two others, on 50-foot wide lots. This is the way this street developed. I submitted with the application a copy of the town assessor's map, which has the parcels at 91 and 101 Henderson in yellow and highlighted in blue the other parcels of the property which contain single-family homes and do not conform to the Residence A minimum square and frontage requirements. Clearly, the vast majority of the homes on the street do not comply with Residence A requirements because, again, they were created in 1922 prior to zoning. The neighbors to the west, Mr. Johnson and Ms. Sayers, have submitted through council a statement in opposition to the variance application. I, in turn, submitted to the board a statement in support of the application and indexed several attachments. I will not repeat the arguments made in my submission, but would like to emphasize a few points. One, the parcels at 91 Henderson and 101 Henderson have not merged. The parcels were purchased separately, 2 years apart, and have not been merged in any legal manner. The clear evidence, namely the fact that the house and garage are all located on 91 Henderson, as well as the email of Patricia Carroll, the daughter of the prior owner, to the board, makes it clear that the lots were intended to be used separately. Secondly, this is not a state of facts that creates a self-created hardship. The Kulak case I cited in my submission states that the applicant, that in the event the applicant creates a nonconformity, the board lacks the power to grant a variance. That's not the case here. The legal hardship here is the creation of the lot in 1922, as well as the endorsement of the lot by the Town Plan Commission in 1922, and the later enactment of the zoning regulations in 1925 that make the lot legally non-conforming. The Kulak case states where the hardship is created by the enactment of a zoning ordinance and the owner of the parcel could have sought a variance, then the subsequent purchaser has the same right to seek a variance if his request is supported by law to obtain a variance. That's the case here. I also set forth a fundamental fairness argument as outlined in the Vici case. The court in that case reviewed a situation where the applicants were requesting the same variances that the neighbors had received earlier. The court stated the plaintiffs are asking for no more than what their neighbors were permitted to do on their own adjoining lots nearly 50 years ago and should be allowed to do so. I attached to the submission a copy of the variance approval for other lots on Henderson Road, including notably the property of the opponents. The opponent's predecessor in title obtained a variance in order to approve their lot that their home sits on as a separate lot, and obtained a separate variance to approve the then vacant land to the west as a building lot. I would submit that fundamental fairness supports the approval of this lot as a building lot when the two immediate properties to the west, including the property of the opponent, received virtually identical variance approvals. Given the fact that this lot would have been approved had there been subdivision regulations enforced at the time the lot was created, given the fact that the map actually contains approval of the Town Plan Commission, but again, there were not subdivision regs, so it cannot be considered a legally binding subdivision, given the fact that the clear intent of the owners was to maintain the property as a building lot, given the fact that the town of Fairfield has historically assessed this property as a building lot, and the owners have paid taxes on it as a building lot, and I have proven that this has been the case for at least 40 years, given the fact that the configuration of the lot is consistent with the neighborhood, consistent with the property directly next door and directly across the street, I submit that a more valid case of the existence of a legal hardship would be very, very difficult to find. I've also submitted an updated petition containing the signatures of 22 homeowners on Henderson Road, all in support of this application. For the reasons I have outlined, I'd request this application be approved. Be happy to answer any questions the board may have. I appreciate your patience.
Thank you, Attorney Fitzpatrick. And just for the record, so we're clear, we have the original packet, but we also have an opposition that was filed by Attorney Markley on behalf of the people at 111 Henderson, on behalf of Johnson and Sayers. And we also had, as part of the record, Attorney Fitzpatrick's statement in further support to address those comments and provide additional support, as he just mentioned. So now, any questions from the board of Attorney Fitzpatrick? Jane?
Hi. I'm looking at vision appraisal for 101, and under building attributes, it's under style, it says vacant land. Is that a legal term, or is that just what?
No, that's an assessor's term.
That's not, has no legal bearing on this particular property?
No, it does not.
Okay, thank you.
Any other questions? Faith, Terry, Katie? Okay, all nods of the head negative in that. Okay, Jane, any other question? Okay, nod of the head no on that. So now
Kevin, I think
invite
Katie had a
anyone.
question. I'm sorry.
Excuse me?
I think Katie had a question.
Yeah, I just wanted
did?
to, I think, I'm pretty sure you said it, but I just wanted to confirm that over the years, it looks like the valuation of this lot, we've been paying tax as if it were a building lot, not a, because it's at the same valuation as the property next door, so they've been taxed as if it were a building lot. Correct?
Yeah, to be specific, the existing valuation today for land only at 91 Henderson, which is the house lot, is $243,100.
Right.
Whereas the appraisal today for 101 Henderson, the vacant land, is $202,600. Given the fact that the 91 Henderson is connected to the sewer system, et cetera, I think that explains the difference. There's no question that 101 Henderson is not being taxed as excess land. It's being taxed as a building lot.
Yeah. Sorry, any other questions? All right. Anyone wish to speak in favor of the application? If you're on the video, you can do a little raise your hand tab. Are we aware of anyone on call-in in favor? Not hearing anything. Is there anyone in opposition? Matt, do you know if Attorney Markley was going to also speak in opposition, or was he just doing his submission?
To the best of my understanding, he said he was just going to submit what he put in last month.
No.
That everybody has. but
No,
maybe
it looks like
online.
Attorney Markley is both on the conference call as well as Mr. Johnson, who was referenced. So I'm assuming that they may want an opportunity to speak.
Okay.
Okay. Attorney Markley?
I'm here. Does anyone hear me?
Yes.
Yes, we can hear you.
I'm sorry. Oh, well, thank you, because no one let me into the meeting. I tried to get into the meeting through WebEx, and the host was notified that I'm here, and that was the last thing. Nobody let me in. So I'm glad that you can hear me.
Yes, Attorney Markley, we can hear you. We have your submission, which was forwarded to this, and I want to make sure that if you want to have further comments, you can do so.
I do. Thank you very much, Mr. Chairman, members of the board. I'll try to keep this brief. I was not provided with a copy of Mr. Fitzpatrick's supplemental submission, whatever it is, so I don't know what's in it, and I have not seen it. But let me comment on a few things. This is not a legal building lot. It is not designated as a separate building lot by the assessor, and it makes no difference what the assessor does with the lot. It doesn't alter the fact that the lot, the parcel, does not conform to Fairfield zoning regulations. Mr. Fitzpatrick indicated that it was purchased, these two adjoining parcels, which his client now owns, were purchased in two transactions 2 years apart. I have no evidence of that. I submitted a copy of the deed with our opposition that shows both parcels were transferred to SUG LLC on May 22, 2020. And if you look at the vision appraisal reports that I attached to our submission for both of those parcels, you will see that that was the date of transfer for both of them. So I'm not certain what Mr. Fitzpatrick is referring to when he suggests that they were purchased in two separate transactions. They were purchased in one transaction on May 22nd, 2020, approximately 11 days before the application was filed. I have not looked at the Kulat case because, again, I did not have Mr. Fitzpatrick's submission, so I don't know what's in it, but this is not a legally non-conforming parcel. It is non-conforming. It is not a legal building lot under Fairfield zoning regulations. Our submission sets forth the reasons for that. The Vichy case I am familiar with, to which Mr. Fitzpatrick referred, that deals with the question of fundamental fairness. And in that case, the seller sold off 4 parcels, all non-conforming. The first 3 parcels were approved for variances. The 4th was not. And the owner of that parcel appealed. And ultimately, the trial court judge said fundamental fairness requires that it be treated the same way, and therefore overturned the zoning board. Let me point out a couple things. First of all, the Vichy case is a Superior Court decision that was never appealed. So no appellate court has ever approved or countenanced that ruling. It is a stand-by-itself ruling that has never been repeated. The case has been cited once, as far as I can tell, by another Superior Court, and in that case, the decision was not approved. It was found to be totally distinguishable from the facts. So the Vichy case does not permit this board to deviate from the zoning regulations that exist and to grant a variance simply because there are other properties in the neighborhood that may have been granted variances. Basically, it's a case of 2 mistakes don't make a right. In this case, the argument that we have made, and that I think is most fundamental, is that there is no hardship. Hardship, the board is certainly familiar with all the requirements of hardship. It has to be extraordinary. It has to be significant. It has to be unique to this parcel. And there is no hardship. And more importantly, hardship that is self-imposed or self-inflicted, it cannot be countenanced by this board, and the board cannot grant variances when the applicant has itself, in this case, purchased the parcel with knowledge that it was not a legal building, with knowledge that it could not be developed without variances. And yet, this applicant went ahead and purchased this lot knowing that it was not a legal building lot. And Mr. Fitzpatrick has acknowledged that under the statute and the town's regulations, it is not currently a legal building lot. Whatever the prior owner's intent may have been is irrelevant. However, the tax assessor may have taxed that lot, and I don't know that it was taxed as a building lot or as excess land. It's labeled vacant land. Makes no difference. That does not alter the zoning regulations, which still apply. And the neighbors, Mr. Johnson and Ms. Sayers, who live immediately adjacent to this lot, care a great deal that the law be enforced as written and that the board not deviate from it without adequate grounds. And adequate grounds in this case requires a clear demonstration of hardship, which has not been shown. The variances in this case are fairly significant. The two lots in question were purchased together as the two lots would conform together, lot 89 and lot 90, or 88 and 89, I believe, on the assessor's map. The two lots which SUG LLC purchased in May together conform and can, if the owner chooses to build a new property, a new house on that those two lots, that's fine. But the owner cannot build a lot on a house on a lot that does not conform to zoning. The board has made it clear that it requires exceptional and unusual hardship, and that has simply not been shown here. The financial hardship, as I've noted in our opposition, our statement, and I hope everyone has received that statement. I know Mr. Decker indicated yesterday that he would email it to all the board members. I'm not certain why they didn't have it before that, but hopefully you all have it now. If you look at vision appraisal, the statements that I submitted, the ones that Mr. Fitzpatrick submitted with the original application were old. They did not show the transfer to SUG LLC. The ones that are attached to my submission both show the purchase by SUG LLC of these two parcels on May 22nd, 2020. And it shows that the total purchase price for both parcels of $315,000 was attributed to the parcel that has the house on it, which is not the parcel that is the subject of this variance application. The purchase price attributed to that parcel, which is the subject of today's application, was $0. And if you look at the vision appraisal reports attached to our submission or opposition, you will see that that was the case. And I checked today, that is still the case. That has not been changed. As I said, these are not insignificant variances. The request to reduce the area is a request to reduce it by 20%. The request to reduce the frontage and the square permitted on the lot is a reduction from 75 to 50 feet. That's 33% reduction. How these parcels was described in a prior deed or as separate parcels makes no difference. They are still subject to zoning, and 101 Henderson Road requires the approval, requires hardship in order to have variances approved. The fact that other parcels on this street are similarly sized is attributable to the fact that they were developed before zoning regulations, or they meet the current zoning regulations, and therefore there's no issue. But this lot does not. And the fact that the prior owner did nothing to change the zoning classification, or the tax classification, or to eliminate taxes on this vacant land, it does not affect the zoning board's obligation to deny this application based on the fact that there is no genuine hardship. I think I've covered most of what I was going to say. Give me one moment to look at my notes. Now, and I would point out that, you know, I'm surprised that Sugg LLC bought this property without knowing that it was non-conforming, knowing that it could not be built on without variances, that it would have bought this property without some contingency for getting variances, but that's not this board's problem. Nevertheless, the current owner purchased it knowing what the issue was, and therefore any hardship was self-inflicted and self-created. And whether, you know, this lot is consistent with other lots on the street, again, not relevant. That is not the criterion for determining whether a variance can be issued. The criteria are very clear. It's hardship, true, non-financial, non-self-imposed hardship, and that simply doesn't exist here. And I thank you for your time. I apologize if I'm a little rattled, but I've spent the last half hour trying to get into the meeting, not realizing that, well, that I wouldn't be able to join the meeting as the instructions indicated I would. So I thank you for your time.
Thank you, Attorney Markley. Is there anyone else in opposition? Attorney Markley, did your client wish to speak, or are you speaking on his behalf?
I don't know if he wishes to speak. I don't know if he was able to get through or not. I know that.
It's Scott Johnson, the owner of 111.
Good.
Yeah, I had the same issues that George did getting on, but I'm on. I heard every word that George uttered. I didn't hear the entirety of the meeting itself, but yes, George very clearly and succinctly and accurately voiced the objection. So thank you.
Good. All right. Thank you, Mr. Johnson. Anyone else in opposition? All right. Hearing nothing further. Attorney Fitzpatrick, you've already somewhat had a rebuttal of Attorney Markley, but to the point, to the extent he raised some new issues in his comments, do you care to speak?
I would like to, Mr. Chairman. First of all, I should note that my supplemental submission has been available in the zoning office for a week. The fact, I certainly agree, it's not a legal building lot. That's why we're here. The point I was making about the purchase of this property in two transactions was the original purchase from Mr. Henderson, who apparently named the street after him. And in 1924, 91 Henderson Road was transferred to Thomas Carroll and Teresa Carroll. And then subsequently, 2 years later, in 1926, the property at 101 was conveyed by separate deed to Thomas J. Carroll and Teresa Carroll. There's no question that the intent was to convey a building lot. There's literally language in the deed that states, it's a condition of this deed that no building shall be erected on said lot nearer than 30 feet to the street, and no dwelling lot costing less than $4,000 shall be erected thereon, and no outbuildings other than a garage incident to said dwelling shall be placed on said lot. That's the point I was making. The fundamental fairness argument in the Vici case speaks for itself. I'm not going to go further on that. The legal hardship in this case, I think, is crystal clear. This lot was created in 1922 by that Riverside Park map. It was endorsed by the Town Plan Commission in 1922, and zoning regs came into effect in 1925. Nothing could be clearer than the legal hardship that that state of facts presents. This notion that because it's been purchased by a different entity, that the hardship goes away is just contrary to law. The fact of the matter is that this is not a purchaser with knowledge that poses a problem. It's rather a situation where the legal hardship, which is clear, runs with the land. I outlined that earlier, the Kulak case, which states where the owner of a parcel could have sought a variance, then a subsequent purchaser has the same right to seek a variance, and if his request is supported by law, to obtain a variance. That's exactly the case here. I did not hear, maybe I missed it, anything from Mr. Markley about the fact that his client is living in a house that was created by virtue of a variance. The variance for 111 Henderson, if I can read from the submission, which is in volume 1081 at page 43, says, the variance that was sought was a variance of 5.1.1 to reduce the required lot area from 9,375 to 7,500 square feet, and the required square from 75 feet to 50 feet, and section 5.2.4 to reduce the required sum of setbacks from 25 feet to 23.3 feet, section 5.2.4.3 to reduce the required rear and side setbacks from 10 feet to 9.7, and the side from 10 to 3.7 and 4.3, and section 5.2.5 to increase the allowable lot coverage from 20% to 25.8%, and permission to establish a single-family residence. I mean, if I've ever seen a case of a pot calling the kettle black, this is it. That's a litany of variances required for 111 Henderson. To now say that a vacant lot with a valid legal hardship should not be built on, I'm not going to go further. The way the purchaser allocated the state conveyance tax, you have to pay a conveyance tax on $315,000, whether you put 100 here and 215 there, or 315 all on one. It makes no difference. That's the way the state conveyance tax is calculated, and how Vision Appraisal listed the division of the purchase price has no impact on this matter. Lastly, I would just reiterate, there's a classic legal hardship in this matter. The lot was created in July of 1922. The plan was adopted by the Town Plan Commission on December 13th, 1922. The Town of Fairfield zoning regs were enacted in August of 1925. The fact that a lot existed prior to the creation of the zoning regulations, was recognized by the town as a legal lot, was taxed by the town as a building lot, and is fully consistent with the configuration of the neighborhood in general, including the opponent whose house sits on an identically sized lot, is a clear legal hardship. Rarely have I presented your board with a clearer hardship. For the reasons I've outlined, I request this application be approved.
Thank you, Attorney Fitzpatrick. That closes the hearing on Henderson.
I'm sorry, may I ask one more question?
Yep.
The drawing that's submitted, the site plan, includes a footprint of a proposed house, but there's no architectural drawings that accompany it. But does this application include the exact footprint shown on this site plan, so that, which is compliant all as far as setbacks and coverage? In other words, if this is approved, this is the footprint of the house that will be built without any future variances being asked for?
The representation I would make to the board is not that this is necessarily the precise footprint, but that the intention of the applicant is to construct a conforming lot, conforming home, conforming to setbacks and conforming to lot area and conforming to FAR.
So that's, that you're saying that's a condition of your
I'd be
application?
happy to have that, literally, it is a tight lot with a 50-foot width. And we discussed requesting a variance for the some side yard setbacks. And the decision was made that we're not going to do so. We're going to deal purely with the lot as it is. And we will I'd be happy to accept the condition that the home to be constructed be in full compliance with the regs, with no further variance requirement, a variance application by this applicant.
Thank you.
All right. Before I close it, any other questions? Okay, hearing none. It's closed on Henderson. Our next item is on the general docket. It's 41 Alden Street, map 182, parcel 503. Petition of DRs Andrew and Lori Grunbaum for a variance of the zoning regulations, section 5.2.4.3, to reduce the side and rear property line from 10 feet, proposing 5 and 7. Permission to install an in-ground pool. And I believe, Mr. Clark, are you presenting this?
I am. Can you hear me?
Yes, thank you.
Awesome. I will say that in this call, this conference, my audio was going in and out, so just raise your hands if you can't hear me for some reason. I'll try to keep this succinct and clear. I am a landscape architect, the agent for Drs. Andrew and Lori Grunbaum that do reside at 41 Alden Street. They are on the east of the street, and they wish to install a swimming pool, a lap pool, which would require a variance from is a 10-foot side yard and 10-foot rear yard requirement based on the current regulations to get that pool in. They're just proposing a pool that's minimally safe, 10 feet wide, 31 feet long. And I'll read right off the application that specifically the regulations that are being highlighted here that we're requesting a variance from would be 31.2.37, which it's not really actually a variance of this. It's just this particular zoning item, which identifies swimming pools as accessory structures is related. It's no, we're not getting a variance from that, but that triggers the accessory structure requirements as set forth for residence zone B, which is shown at 5.2.43, 4.3. The chart that indicates that if the item, the structure, accessory structure that requires a setback is less than 60 feet from the street front line, it triggers the 10-foot side and the 10-foot rear. And I guess I should also make sure that everybody has 3 drawings in front of them. Is that correct? You have a survey, you have a site plan, and you also have my what I call the screening of proposed pool plan. It's colored.
Yes.
Okay, great. I have that right behind me here as well too. We can talk about it if need be, but it's there if it would be helpful to talk about the specifics. My understanding of the regulation. First of all, I should mention that this lot is undersized. It's a non-conforming lot. It's almost 4,800 square feet, and the typical conforming lot standard is 6,000 square feet. So it's a small lot. It's about between 63 and 64 feet deep, depending on which side yard property line you measure. So the idea of getting a swimming pool in conforming with the zoning regulations would be very, very difficult. It would be impossible to end up with a pool that's ridiculously narrow. So, and the other thing to realize too is that the sunlight to the I'll point to the map here is largely available in the northeast corner, and having said that, I'm going to also mention my understanding of why this I've lost connection with you guys. You guys see me over here?
Yep, yeah, we can see
All
it.
right. Just popping up for a sec. Is that the when you have a shallow lot and you want to do something in the rear yard, the concern is putting something back there that may be visible from the street. I believe that that's why if you're less than 60 away from the street line, you got to tuck it behind the building. So that's why you have 10 feet, and that's the minimum 60 foot. Excuse me, that's why you have the minimum rear yard as well, to 10 foot in the back. So it's basically you're trying to tuck it behind the building, I believe. And if anybody has a different understanding of that, I'd love to hear that. But I believe that that's the intention of that regulation. So, so if you look at the drawing, and you can look at the site plan, which has been prepared by an engineer, that shows the pool in the back left-hand corner, 5 feet off the side yard, and 7 feet off of the rear yard. And I'll give you a second to find that. And that's to try to capture some sunlight. There's not a lot back there. Now, obviously, they put a tall house on this property, but the reality is that has an impact on the sun shadow pattern. But the reality is, even with a lower house, a much lower house, given the fact that the regulations are trying to tuck it right against the house, in this case, it would have to be right against the house. It would create a challenging shadow pattern as well. But that's the idea, is to try to have access to sunlight, in that northeast corner. In so doing, and putting the pool there, it would have an effect on a couple of the subterranean Caltech storage units that were there as a result of the house being built. And you can see that the Caltech ones, I'll point to it on the plan here. Hopefully you can see what I'm. It's very light, kind of an outline, but there are, I think it's 7 of those Caltechs, 2 of which would be impacted by the placement of this pool. And then, so the engineer has placed them to the south as an alternative, and showing the level pipe that would connect the whole system. So, in their estimation, it's possible to do this. And if in fact I'm correct in understanding that the regulation we're asking to be waived, the zoning compliance we're asking for the variance for, is to make sure that the structure is not visible from the street, I prepared the color plan to show you what's out there. And the house on this plan is, as you probably can well imagine, just having looked at the previous plans, begins in the north here, right halfway through this blue area, which is all bluestone terrace. Under the house, it's raised up for flood reasons. And it continues on in the one area outlined by the typical architectural symbol. There, particularly, again, concealing the proposed accessory structure from the street is accomplished by multiple layers on this property. And I will say that our original intention to locate this pool in this corner, but the result is that we have a variety, excuse me, we have a variety of layers of screening. The first of which is a hedge that is indicated as number 1 on the plan. It's a 6-foot high viburnum hedge that's being maintained at a 6-foot height. There's also a cross section on this plan too that shows in the bottom right hand corner of the colored drawing. It shows you if you're a pedestrian or as if you were a vehicle. You see the kind of the pink symbol for the vehicle there. You can see there are a variety. Number 1 shows you the hedge that occurs along the perimeter of the property. Excuse me, I have to take a sip here. And then behind that, we have a 6-foot high fence that's indicated as number 20 and 24. So if you go straight up from 1, you'll see 20 and 24. There's a gate there. And that wraps around the corner of the property here. And we also have indicated as number 3, 2 hawthorn plants that are being maintained as a raised hedge. So you have essentially a wall blocking any pedestrian view from the street of the proposed pool area. And the balance of the property related to views to the proposed pool area. This is a solid hedge of, it's actually, I shouldn't call it solid hedge, but a very tightly planted hedge of arborvitae number 31 in the bottom left-hand corner of the colored plan that are about 7-8 feet tall now. There's a little bit of a gap between them, but we're allowing them to grow together as we will everywhere. And as you continue along the northern property line heading east up the top to the top of the page, arborvitaes continue all the way there. Plus, there's also a stockade fence, solid running board fence, actually, as indicated as number 19 on the neighbor's property. Along the eastern border, we have continuous vegetation there as well, and that is the same arborvitae. These are emerald green arborvitaes. There's about a foot gap between them now, but those are allowing to be grown in. They're about a 7-8 foot height, but we're intending to let them go to about 15 foot height. And you can see cross sections also from the neighboring houses, and that would be shown at that same cross section. You can see that one of the neighbors to the east has a deck, and so she actually would be raised up there a little bit. The hedge that's there right now is about 8 foot along her property line, and that was actually just screen a generator that you guys allowed us to build in that upper right hand corner. But we really we tucked those in very, very tightly. They're touching already, and they're effective to a height of about 7 to 8 feet right now. And as a result of this year's growth, will probably be 8 or 9 foot thereabouts. And these are a variety of green giants that get very tall very fast. So the Grunbaums, who really want to be good neighbors, have tried to take into account screening, obviously from their standpoint, but also from the neighbors. And also in the middle, just to let you know that there's a break in the arborvitae along the right-hand side of the pool. These are Tardiva hydrangeas, which you may be aware of. They're very fast growing, and they're going to be allowed to get to be about 8 or 9 feet tall, maybe even go to 10. They're flowering, beautiful for the neighbors as well, and they have a long bloom time. But there's going to be a continual barrier. So they also have their own the fence along they have 2 fences along the east side that are 6 foot height, running board fences, completely opaque. They have an older one that they actually built in front of that is on the neighboring properties. And so they have multiple layers of visual separation and some sound as well too. Along this side, we have the arborvitae ends here, but as we're now getting into the phase of the rear garden improvements, we're going to be adding a couple of Japanese maples that will be allowed to grow into an arch. So this will be completely opaque in terms of visibility from this neighbor, who also has, you can see that there's a rectangular dashed line in green there. It's a very tall hydrangea. It's a PG hydrangea that grows well in the shade. It's very dense. Which they take on as a maintenance issue, but it's a dense screen there as well. So this proposed pool area is flanked by significant planting that will only get bigger and denser and more opaque, and also by a 6 foot high fence. So it's not like we're starting from scratch. We have a lot of stuff out there that is preventing the neighbors from seeing this pool. To let you know, Dr. Grunbaum petitioned the neighbors. There were 7 contiguous neighbors that were approached, 5 of which endorsed the plan. The neighbor to the south here, said that she would approve the application if, in fact, she couldn't sell her house because the generator was placed in that corner, and she approved the generator previously. For some reason, that she's changed her view, and I think it's because a realtor talked to her, that if the Grunenbaums can't sell their house, excuse me, if the neighbor can't sell their house, her name is Ms. Savage, that the Grunenbaums would have to move that generator to a different spot. And the Grunenbaum's not willing to accept that condition, if you want to call it that politely. She has not signed this application. But just to reiterate, the arborvitae that flank the generator are dense. There's also a little piece of lattice that we put in temporarily around that wrapped around the platform here. It's a temporary structure. It's going to be removed once these arborvitae get bigger, and we did that to the benefit of the property to the east as well as for Ms. Savage. So any gaps that exist from brand new plantings, even though they're minimal, have been minimized further by the lattice. So Grunenbaum's gone out of their way to basically say thank you to their neighbors for working with them, and they can something could be conceived as less than desirable. But even if the generator were moved to a different spot, it would be much more visible. So it seems like it makes a lot of sense that this neighbor would be accepting of the fact that it's there, and it's a very, very quiet. And not to bring that up as a separate issue, but that was brought up by the neighbor. So I want to let the zoning board of appeals know that that was the condition for denying that signature. She wanted to use that as leverage for some reason. And I think it's because a realtor mentioned that to her, which seems a little bit unreasonable at this juncture. But that's what's going on. And the other neighbor just would not come to the door. This is number 60, which is down here across the street, which would have no visibility to the pool in any way. And she, for the second time, has not come to her door for the first variance application. She didn't come to the door for that. She hasn't done this. She's done the same thing. So again, the pool is 10 by 31, which allows for very narrow stairs over here and a what's a minimally comfortable lap width, so that you're not hitting the side of the pool. And I don't know whether it's self-explanatory with the photographs that are on the right-hand side of this diagram here, where you can see what the arrows are. They're fairly faintly printed. So if anybody has any questions about what view is what, I'd be happy to review that with you. But as a non-conforming lot, it's shallow, and there's not a lot of room to do stuff back there, and they're just asking for a minimum width pool to be able to enjoy some private swimming.
Thank you, Mr. Clark. Does the board have any questions for Mr. Clark? Jane?
Hi. Couple questions. The pool equipment, which is your number 30, that's tucked up against the house.
Yes.
How much noise does that make?
When the filter is running, it's not a loud noise, but it's definitely audible. But it's not. I don't have the decibels on that. It's quiet.
That's the closest thing to the Mrs. Savage house. Do they know that?
I don't know whether Dr. Grunenbaum mentioned that to them or not, and I don't. He being a good neighbor is not trying to pull anything over on anybody.
Yeah, I mean, is there another location that's not so close to their house? Did you explore any other locations?
There's not a lot of space, given the, but we could tuck it over here in the corner by the. That would again be within the 10-foot setback. So in this case here, we're actually conforming.
Right.
Back there, we wouldn't be conforming. So it's possible to put it next to the generator, and we just would extend the whatever as needs be. Although it may have somewhat of an impact on the drainage structure, may have an impact what we can do below the surface. You guys are your picture jumping in and out a little bit, so hopefully you can still hear me.
Yeah, we can hear you. And then the because you're submitting this drawing with all the plantings, that's part of the application, is all the plantings as well.
Yeah, they already exist. The only thing that doesn't exist is number 10. And that'll be the last phase of this because they need to have construction access to get to the back. And once that's done, we'd be planning two upright Japanese maples and create shed. And so yeah.
So yes, the plants the planting plan is part of your application. That's
Yeah,
part of.
but it all exists out there. We would be maintaining those. Yeah.
Oh, okay, thank you very much.
You're so welcome.
Any other questions? Seeing and hearing no other questions, raise hands. Oh, Katie.
Sorry, I was muted. I just want to make sure I'm understanding the application. They're asking to reduce the side and rear property lines from 10, proposing 5 and 4.
5 and 7.
Sorry, 5 and 7. But now, don't our zoning regulations say that a pool only has to be 4 feet off the property line? Well, I think I missed the part of what changed that, or why that's not the case.
So my understanding is since the object that is to be set back is less than 60 feet from the street line, suddenly triggers a 10 on the side and a 10 in the rear. Okay, so and it's like, yeah, my first thought too, why would they do that? Well, my understanding is that since the object is closer to the street, they want to tuck it behind the building. I think that's the concept. And so the
object being what? The object being the pool or the generator?
Pool or anything, any object. And so we had to deal with that with the generator as well because we have a shallow lot. Because it's only 60 feet the whole way, and it's a minimum requirement from the street property line, which is here. You got to be 60 back.
The generator, it's in the generator. There was already a variance granted for the generator, correct?
Yeah. So we're not asking for that now, but that same condition.
That triggered
it's the same issue. Yeah. But we have screened it like as much as you can screen anything.
Right, but you already had the variance for the generator, but that triggered the increase from 4 feet to 10 feet on the side and back line?
Yep.
Okay.
It's a little different. But
what regulation is that? Did I miss that? I know you guys referenced 2 of them.
Yeah, it's 5.2.
Yep.
0.4.3. Yeah. And it's like the last part of that paragraph, I think. It's just part of the chart.
I'll see it, but okay. Maybe Matt can clarify afterwards.
Yeah, I think so. I had the same conversation with Matt. I'm not trying to put words in his mouth because I'm sure he can explain it better than I can. But I think that is the concept. And again, if there's something else that is not addressed in that regulation that we've missed, but I think it's primarily visibility.
I'm sorry, can I ask one more question?
Yes.
I'm just measuring what you have on here. If you needed to, could you, if you shrank the size of the pool so that it did conform to the 10 feet and the 10 feet, and then slid it over more?
It just makes it's not very safe to swim in. It's just like a standard lap pool is minimum 10 foot wide. That's why they're asking.
For 2 lanes or 1 lane or?
It's really 1 lane. It's just with the pool steps, etc. They may try to do 2 at once, but 10 is pretty tight.
For 1 person, 10 feet?
Well, no, 10 feet is tight for 2.
Yeah.
Okay, but 10 is sufficient for one person to be comfortable. Not to get my personal situation in this, because I'm sure they're much better swimmers than I am, but I migrate when I swim, so I go left to right. Whatever. It's what they identified as the minimum they would feel comfortable swimming in safely.
So that is a lap pool versus a plunge pool, which can just be any size that you want to just jump in and cool off.
No, plunge. Really, the plunge pool typically is no less than 16 to 18 feet wide, because you just don't want to be jumping to it from side to side. So this is this. Even though it has a step to jump in and do that, it's not going to be a diving pool. This is strictly a lap pool, and it would require educating anybody using it that's all it's for.
But you could, if you made the pool smaller and conformed to the 10 feet on either side, you wouldn't need a variance at all, right? That's my point.
It's correct. The other thing that happens, so you'd end up with a less than one of the reasons why we're asking for the goodness gracious, asking for the encroachment into the rear yard is the fact that we have to do around the pool. The actual width of the pool itself, yeah, if you went down to like a less than 7 foot wide pool,
Yeah.
you could physically fit it in there, but it's just, it's not very wide. And it's possible that somebody would hit their hands as they're, because when you're swimming, you're not looking, you're sort of breathing, you're in your zone, and
Right.
somebody could get hurt. So I don't want that to happen.
Yeah.
One more.
Yeah. Thank you.
You bet.
One small question. If the pool were moved over 5 feet, so
Mhm.
you had 10 feet on the left side, would that encroach on where the Coltec is intended to be placed?
It gets close, and the engineer would have to make that call. But these guys over here have said it's fine, and not skirting your question because it's an issue. But at the same time, pools typically are constructed with a lot of gravel.
Mhm.
So if you're taking groundwater or the water from whatever surface and or actually I guess it would just be roof water in this case here, and putting it into that, it'd be sort of like bleeding it into the pool drainage area, which I don't know if that's good. You have hydrostatic relief valves that allow the groundwater to come up through it to keep the pool from popping out. It's best to keep somewhat of a distance from it. So
You have, thank you. But then, and you have approvals from the neighbors that border both sides where you're asking for variances. You have approvals from both of them from the.
These guys are all cool. So I don't know if you see what I'm pointing, but this one to the left, to the north,
Yep.
The two to the east, yes, and then the Savage is the only one that's holding back.
Okay.
There's two across the street have said yes as well.
Anything further? Okay, thank you, Mr. Clark. Anyone wish to speak in favor of the application? Is there anyone on call-in? Okay. Anyone in opposition to the application?
I am in opposition to the application. I have a point I'd like to bring up.
Okay, and I just need your name.
Okay, this is Karen Savage. I live at 57 Alden Street. And I was not made aware, thank you for asking the question about the pool equipment. I was not made aware that the pool equipment will be close to my property. I already hear a lot of noise from the generator, and I really would have appreciated the Grunbaum bringing to my attention that the pool equipment would be on my side of the property, so there'll be more noise generated for me. So that I'm taking issue with that.
And did you have something further about opposition other than the pool equipment?
I do not.
Ms. Savage?
No, I don't have other concerns about the pool other than I like what some of the questions that were brought up from the board as far as maybe just make the pool a little smaller. If it's a little smaller, it won't even require a variance.
But then the pool equipment would still be there.
Yeah, I have no problem with the pool. I was just asking, I had signed off on the variance for the generator, and then it was brought to my attention that that could be a big problem. And when they approached me again for the variance for the pool, I said, I'm happy to sign off on that. As a good neighbor, I signed off on the other variance. Would you help me out? Because here's a concern I had. And it ended there.
Okay.
Would you like to respond?
Anyone else in opposition? Okay, Mr. Clark, you can respond the opposition by Ms. Savage. It's about the pool equipment and about making it smaller.
Yeah, as far as making the pool smaller, it's a safety issue. It's a comfort issue. And I don't think it's going to have much of an impact. But because we have the fence there, we may actually have a double fence here, depending on if we, because we have to bridge this gap over here to comply with the pool enclosure. So it may, but as far as the pool equipment goes, and the groom moms would be happy to place it in the back here by the generator. The intention here is not a spot that didn't require variance. That's the only place I could think of that wouldn't be in the middle of the yard, making it more visible for everybody. But I do understand what Ms. Savage is saying. It's close, and even though a pool filter is quieter than certainly than a generator, it is an issue. And if the board would be willing to work with us on putting it back by the platform, we'd be fine with that.
Okay. All right, thank you. Mr. Clark, that finishes 31.
Thank you.
And now we're going to have number 2 and number 3. Mr. Papageorge, unmute yourself, please. Are you presenting your application, sir? Your applications?
Yes.
Okay. What I'm going to do, they're basically repetitive of each other, correct?
Yes.
You're going to have to speak up louder. We can barely hear you. Maybe move closer.
Is that better? Hold on, let me see. Is that better?
Let's just make sure.
Hold on. Is that better?
That's a little bit better, but I think you're just going to have to talk loud, okay?
Okay.
All right.
I will try and talk loud.
Pretend like I'm on the other side of the room, all right? And then talk to me that way. Okay?
Will do.
All right. What I'm going to do is, looking at these, they're very similar, and you'll be making the same argument or presentation twice. So I'm going to call them together, okay? We will take them up in voting separately, but I'm going to call them together because I'm asking you, do you agree that your application would be the same for both number 2 and number 3?
Yes.
And anyone who's, since it's difficult to hear Mr. Papageorge, anyone who is not speaking, please mute yourself. Especially, sorry, board members, us too, because if we're looking at paperwork, it may interfere with hearing Mr. Papageorge. So number 2, 1391 Black Rock Turnpike, lot number 1, map 77, parcel 490, petition of Lucas Papageorge for a variance of zoning regulations. Section 5.1.1 to reduce the minimum required lot size and lot square from 6,000 feet and 60 feet, proposing 4,659 feet and 55.02 feet. Permission to establish a building lot for a single-family dwelling premises B zone. And number 3, 1391 Black Rock Turnpike, lot number 2, map 77, parcel 490, petition of Lucas Papageorge for a variance of the zoning regulations, section 5.1.1 to reduce the minimum required lot size and lot square from 6,000 feet and 60 feet, proposing 4,659 feet and 56.06 feet. Permission to establish a building lot for a single family dwelling premises B zone. All right, go ahead, Mr. Papageorge.
My name is Lucas Papageorge. I reside at 121 Woodland Road in Fairfield, Connecticut. I own a construction company, LCP General Contractors, and we do primarily work in Fairfield. I'm a 4th generation Fairfield family. We service the community through public service with restaurants, and even now my company as a remodeler. I'm proud that my company has not needed to demolish any houses in the town in 15 years that we've been in business. I have, in all cases, respected the history of the town, its neighborhood, and its structures. I put forth this application to do the same. Although we have a substantial burden of the lots downhill and sloping topography, and being located on the corner of one of the town's busiest roads, it just does not make sense to tear down a well-built 100-plus-year-old structure
in order to build a two-family house when we could, we have plenty of room to build a secondary house by subdividing these lots. To build a two-family, by putting an addition on the existing structure and splitting that in a condominium with 50-50, having one 100-year structure and one adjoining structure or attached structure as a two-family house, causes a lot of problems when you try and condominium that and make it a 50-50 split. You know, one side's a 100-year-old side, one side's a new side, and to split the maintenance and outside on that house would be a legal catastrophe. So we would need to tear down this house to build an entirely new two-family, and that's what we're trying to avoid here. With my application, so the existing house, the existing lot, it drops nearly 10 feet from the Black Rock Turnpike and all the way down Borowski Road. It's a 10-foot drop in elevation, which causes an attached house problem. This also will create issues with water mitigation. As the property slopes down, putting infiltrators and catching the water from the structure would be an issue there, causing undue erosion control needs, and then staging areas and access to the construction company off of Black Rock Turnpike will be difficult, and cause right-of-way line of sight issues that we try not to create. By working on two separate structures, we split that time, we split that area. We'd be able to access from Borowski Road as much as possible, and we feel that it's a better use of the spot and for the neighborhood. I'm reading off of the list that I submitted. If anybody wants to follow along, this by having a single-family house, it stays consistent with the neighborhood, and having the 10-foot minimum lot in between the two structures would give it, rather than a 100-foot long structure with two family, having two 30, 25-foot wide houses, I feel would be a better visual and keeping in the terms of the neighborhood, especially the doctor's office, the dentist office right behind us. To have just them looking at a 100-foot wide building would be a detriment to his value. So the dentist office, they're well behind our submission, along with every adjoining neighbor. They've all signed off on the form attached to our application. One of the biggest reasons we have for this application is saving it's a 120-year-old structure on the property now. There was an addition put on in the mid-60s or 70s we would need to remove, and we need to put a small addition on in order to keep the house legal as far as the minimum square footage. So that is our plan. The EPA shows that recovery and reuse of just a handful of building materials from a single-family home, we could notably contract the full environmental burden, as noted in the 2014 report from the Environmental Protection Agency. So that's our plan. We would like to reuse this structure just like my company has done for the last 15 years. We've never torn down a house. We like to remodel, reuse, and repurpose the existing structures. There would be a smaller amount of living space. So with the two-family house with the 50% lot coverage, we could do 46,500 or 4,659 square feet. By splitting the lots, we've got it proposed on the one lot with the existing house would be just over 2,000 square feet, and the second house would be the same. We with the setbacks required on the smaller lot, which we're not asking for any variances on, we would maximum be able to get 1,000 to 1,200 square foot footprint on that lot. So it would make the houses smaller. It would have less density, less amount of impervious, and less stress on public utilities. It also would be better for the Black Rock Turnpike. So we would the health and safety. The time we owned this house, We've noticed that there's an excessive speed down Black Rock Turnpike in that area. And by allowing us to do this, we'd be able to increase the sight lines on Black Rock Turnpike from Borowski Drive and from the doctor's office parking lot. We'll remove the driveway on our property from Black Rock Turnpike and convert it to Borowski Road. And we will also give an alternative means of egress to the properties by going down Borowski Road rather than always having to pull out on Black Rock Turnpike. That I would like to also bring into the fact, my friend Mr. Fitzpatrick mentioned, the fundamental fairness. We are not asking for anything that has not been previously approved by this board. This board has approved in over 11 cases in the last 9 years, an application to subdivide a two-family lot into 2 single-family houses. And fundamentally, the B zone, similar lot sizes are found in every area of B zone throughout the town in multiple cases. And then lastly, the neighborhood is in full support. Everybody we talked to, all the signatures we've gotten, and the entire neighborhood is actually enthusiastically behind this application. So with that, I'll leave it to the evidence that we've submitted and open it up for any questions you may have. Thank you.
All right, thank you, Mr. Papageorge. Does the board have any questions? Jane?
Of course I have questions. The drawing shows a proposed addition onto the existing house, but there's no architectural drawings that go with that?
We don't have architectural drawings. We will have to do a subdivision application after this, if this is approved. We'll have drawings with that. We just did that to show that we could within the setback lines, we could make the house meet the minimum square footage that's required by the town to have a single family structure.
No, I'm talking about the existing, the old house, the 120-year-old house.
Yes.
You show proposed addition that kind of swallows up the existing house. So we don't know what that looks like, do we?
It's 9 foot wide coming out, but we have to take off the back portion that's 9 foot wide.
Right, but design-wise, architecturally, we don't know what it looks like. It's just.
No, you do not. We
don't have any. We have no idea what the design of that is. Okay, and then the second question is, where you're moving the driveway, did you check with engineering to make sure it's far enough from the corner where you're showing the new driveway?
We could do that. I will do that. I would.
So you don't know for sure if that
on Black Rock Turnpike.
Yeah. Okay, so that
I prefer not to have it on Black Rock Turnpike.
Right, but I'm saying these are two we don't know enough. I mean, design-wise, it's kind of unclear what will happen to that property. We don't know what the addition's going to look like. We don't know where the driveway is going to end up. So it's a little vague, right? And then maybe it was emailed to me, but I don't have signatures. Was that submitted as a separate document or emailed?
It was emailed to Matt on Tuesday, I believe.
So maybe Matt forwarded it and I just didn't see it. I'll have to look. You did, okay. And then you mentioned that the future house that would go on that new rear lot, you would not be asking for additional variances for that. It would be conforming.
It would be conforming with this variance. The only thing we're missing is the square and the lot size. We would leave the existing setback.
But you would, that's part of your application today is saying that whatever future house goes in that rear lot would conform to all setbacks. Is that what you're saying?
Yes.
Okay.
Yes.
And I think that's it for my questions. Thank you.
Thanks, Jane. Any other questions? Okay, Katie, Terry? Okay, and no other questions? Anyone wish to speak in favor of the application? Okay, is there anyone in opposition? Okay, hearing none. Thank you, Mr. Papageorge. That concludes number 2 and 3. Our next item is number 4. And it is 12 Brookdale Road, map 79, parcel 824, petition of Kenneth Lokanovitz for a variance of the zoning regulations, section 5.2.4, to reduce the minimum required street line setback from 30 feet, currently 29.5 feet, proposing 29.5 feet. Permission to construct a second floor addition with attic over existing first floor premises, A zone. I think I saw the owner himself on this. There you are, sir. All right, whenever you're ready. I can't hear you.
Hold on, let me see. Sorry. He's
No,
not
now you're muted. Okay, go ahead.
He's good.
Still can't hear you, sir.
Hello.
There we go.
Okay,
Perfect.
that's better. Okay. I'd like to take a moment before I begin just to thank Matt Decker for his assistance filling out the application paperwork and also for getting me on this call. With that said, I am requesting a variance to the regulations, section 5.2.4, to reduce the minimum required street line setback from 30 feet to 29.5 feet. If I could direct your attention to the land survey, you'll see that the southern corner of the house is 6 inches over the existing structure, is 6 inches over the required 30-foot setback. And I am looking to add a second story to my house. I have spoken to all the neighbors in the adjoining properties, including the ones across Jennings Road, and I got those 6 signatures and have their permission, and I think that's it.
Yes, we have those signatures in the packet. Okay, and basically you want to just go straight up for your existing structure.
Yes, correct.
Okay. Any questions from the board? Shaking of the head, no. All right. Is there anyone wish to speak in favor of the application? Not hearing anything. Is there anyone in opposition? Well, since all the neighbors signed, I find it unlikely, but let me keep it open to wait and hear. Hearing none. All right, sir. That was quick. Your packet is complete. Thank you very much. That closes number 4.
Okay, thank you for your time.
Number 5, 207 Main Street. Map 241, parcel 4A, petition of Lauren McGrath and Chris Las Paluda for a variance to the zoning regulations, section 5.2.5, to increase total floor area from 30%, currently 36%, proposing 36.1%. Permission to construct a dormer, premises R3 zone. And I think we have an architect on for that. Yes, sir.
Hi, good afternoon. I'm John Dumke of Sterling Building and Restoration. Thank you, Chairman, and thanks the board for being here. And thank Matt for just guiding me through this, mostly the COVID period of trying to do this without getting face-to-faces. So appreciate the time. Yes, I'm here on behalf of Lauren McGrath and Chris Las Paludo of 207 Main Street. They have a lovely little house that built in 1804 on a non-conforming lot. I believe while the variance I'm asking for does not affect the home, it affects the garage structure at the back of the property. And I believe that's a 1900s building. And it's right up against the property. We want to construct a dormer on the south side of that building to allow for a loft office space or workspace up there. Because we're in a non-conforming lot, we began this process, and then we realized we were really just that the dormer itself didn't affect the 10-foot setback, but rather just affected the increase in floor area, I think, which turned out to be 0.1%, which breaks down to, I think, 13 square feet of more space. I've supplied you with design, I believe, and signatures from the surrounding neighbors, as well as the new plot plan showing the dormer.
Yep. Okay. Anything further, Mrs. Dumpke?
Just thank you for your time.
Just because I asked doesn't mean you have to say something. I just, I just want to make sure.
But I mean it. I love this process, and thanks for the time and the consideration. And the only last thing I would say is that if we are able to move through this somehow, I want to be able to talk to HDC this afternoon at their meeting.
All right, let's see if there's any questions for Mr. Dumpke. Any questions? Seeing no questions. Anyone wish to speak in favor of the application? Hearing nothing. Anyone wish to speak in opposition? Hearing nothing again. All right, thank you, Mr. Dumpke. We'll be taking this up later on in this meeting. Number 6 is 257 Roland Road. Petitioner Brian and Maura O'Connor for a variance of the zoning regulations, section 5.2.5, to increase lot coverage from 20%, currently 23.6%, proposing 27%. Permission to construct a rear deck, premises A zone. I think Mr. O'Connor is on. Cannot hear you, Mr. O'Connor. Try unplugging it, and if your laptop has a microphone, it may work. Still cannot hear. Matt, he's off mute, right? Okay, yeah, he is.
He is off mute.
Is there a call in like Mr. Petitioner did? Can you do that at the same time?
You could. Brian, can you hear us? Just nod your head if you can hear us.
He can hear us. Yeah, he's trying different stuff.
You can hear us, okay.
Still no go. Matt, do you have Mr. O'Connor's cell phone?
I do. I'll have to go grab his application.
See if you can call him and try to walk him through to connect.
Yep, give me 1 second.
We can't hear him.
Still can't hear me?
No, I hear you. Perfect.
Okay. Sorry about that.
Someone will have to just bring Matt back. Oh, but you could go. Josephine, are you in Josephine, are you in town hall?
I've got it, so I'm here.
Okay, Matt, his is on. His is on.
You're
All
good,
right, go
Brian?
ahead, Mr. O'Connor.
All right.
Hi, thank you, Mr. Chairman and members of the
great.
board for your time today. My name is Brian O'Connor, and I'm the owner of the property at 257 Roland Road. And our application is before you along with a survey as well as actual drawing to get approval for a variance for lot coverage. The hardship is that if you look at the survey, you will see that previous owner, 2 or 3 previous owners had built a very large garage to accommodate his construction equipment. So you'll notice that about 400 or 500 square feet in back of the garage does cover quite a bit of our land, and it really is just for storage. It's at ground level. We are in the flood zone, so it's not an area that can help us at all as far as living requirements. So any improvements that we want to make to sort of our housing and our structure, we're going to be over the lot coverage. So with that in mind, what we're looking to do is simply add a 24 by 20 wood exterior deck. This would allow us to, be able to enjoy like outdoor eating because of the flood zone. We obviously are about 5-6 steps up and down. The area that we're proposing would just simply be put in the same footprint as our existing patio is now. So we're not adding, any additional coverage. And because it is going to be above 12 inches off the ground, it is considered a living structure, which is why we need to come before you and try to get the variance granted for us. I did speak and get signatures from all 4 neighbors that are adjacent on the A2 survey that you see there. And just as a clarification, if you're looking at it, it does say on there a proposed patio to the left. That's an existing patio. That's not a new patio. That's an existing patio of brick along the ground. So that's not new. The only new structure here is the 24 by 20 exterior wood deck. So that is it. You should have the information in front of you, I hope, including the petitions, the survey, and the drawing. And I'm happy to take any questions.
Okay, thank you, Mr. O'Connor. Does the board have any questions for Mr. O'Connor? I have nods of the head negative. Okay, anyone wish to speak in favor of the application? Is there anyone in opposition to the application? Okay, thank you, Mr. O'Connor.
Thank you.
Number 7 is 1514 Hillside Road, map 171, parcel 11, petition of Elizabeth Fath for a variance of the zoning regulations, section 2.9, to enlarge a new conforming second dwelling, and section 5.2.4 to reduce the side setback from 30 feet, proposing 21.4 feet. Permission to construct a second floor addition to the cottage and a generator enclosure. Premises AAA zone. I think Attorney Fallon is on this.
I am, Mr. Chairman. Can you hear me?
Yes, we can.
Wonderful. Well, good afternoon to the members of the board. Again, as I said last month, thank you so much for your continued diligence during this very unusual time and keeping the business moving forward. I'm pleased to be representing the FAST. I believe Elizabeth may be on the call, as is Paul Tallman, our builder, and Paolo Vincente, our architect. Just a quick couple of things on the call, typos, but as I'll put forth in my material. In the second line there, it says to enlarge a new conforming second story, a second dwelling. Obviously, the term there should be non-conforming because the dwelling already exists. And similarly, there's a reference, permission to construct a second floor addition. Actually, there is a second floor already existing on the property. What triggers the variance, as I'll discuss in a minute, is the desire to create a second floor dormer. So having said that, the property is located at 1514 Hillside Road. It's a triple acre zone. It's a very large parcel. It comprises 7.142 acres. For many, many decades, existing on the property along with other structures is a single family primary residence and an additional cottage, which is the subject of this application, that's been utilized as a residence for many, many decades. The use of both, obviously, the primary dwelling and the non-conforming cottage are both legally protected pre-existing non-conforming uses in that these conditions predate the adoption of zoning regulations in Fairfield. What Ms. Fath would like to do is to renovate the existing cottage by adding a small second floor addition consisting of a second floor dormer. As I said, there is already a second floor on the cottage, but we would be enlarging that somewhat with a dormer. The work will also include replacement of siding, windows, and doors. And we're also requesting approval to build an enclosure around an existing air conditioning condenser and generator on the property. But those utilities already exist. We would just like to enclose it, as I'll elaborate on. I want to emphasize that I think the variance is very technical in nature. The existing cottage already has presently 2 bedrooms located in it. The purpose of the renovation is to reconfigure and update the cottage interior with regard to the existing bath and kitchen. There will be no increase in the number of bedrooms after the renovation of the cottage. It's complete. It has 2 bedrooms now. It will have 2 bedrooms after those renovations are done. In addition, if you look at the plans, you'll see there's presently a 3-car bay or 3-bay car garage. We're going to be eliminating one of those bays. So I think that's a very good thing because the end result is we're going to reduce the massing of the current structure. So the end result of what we propose with regard to the cottage will be that the use of the property will remain exactly the same as its historic utilization has been for many decades. There'll be a primary dwelling, which continues to exist, and the smaller accessory dwelling, which consists now and will consist then of 2 bedrooms. I pointed out at the beginning of my comments that this is a very oversized parcel in the zone. It's over 7 acres. Obviously, the AAA zone allows a dwelling unit based upon a minimum lot area of 2 acres. So that I think what we have here is a situation where renovating this existing cottage, maintaining the pre-existing non-conforming status of the 2 dwelling units is certainly not inconsistent with the comprehensive zoning plan as recognized by your regulations and is not going to adversely impact the neighborhood in any way, shape, or form. As you know, a pre-existing non-conforming use, which predates current zoning, is a protected use legally under Connecticut General Statutes 8-2. The fact that the proposed addition basically of a dormer triggers the need for the variance that we request does not change the fact that this protected use, which runs with the property, is protected, and therefore, as I'll elaborate on in a minute, this provides a proper basis for the granting of this technical variance. With regard to the variance of section 5.2.4 concerning the enclosure of the existing utilities, obviously those utilities exist now, and functionally and aesthetically, we simply want to enclose them. We think that has a benefit from both a practical and an aesthetic standpoint. So having taken all that in consideration, you have to, and I hope the facts you will agree, support a finding that we've satisfied the provisions of section 8-6, which sets your standard for action. One, that the proposal is not going to have any adverse impact with regard to the comprehensive plan. And 2, there is and are factors, excuse me, that establish hardship for the purposes of granting the variance. Obviously, there's not going to be any change to the comprehensive zoning plan here, in that, as I've elaborated, the use of the property is going to remain exactly identical to its historical utilization. It's also going to be very consistent with the use of the property and its pre-existing status for many decades. I've submitted, as part of the material over the last few days, petitions from all of our surrounding neighbors on older sides, both sides of the street, etc., So they're all aware of this, and I think it's fair to say that they are very appreciative and happy that this important and very beautiful piece of property under now the FAST, who are newer owners, ownership, there's really a commitment made by them to bring this property up to the stature that it once had and should have again. And I think the neighbors are very, very enthusiastic about that from what we've heard. With regard to the hardship, obviously, I think we do have a situation here, as I point out in my memorandum that I submitted, where the application of the regulations to this property and its historic use does have a significant impact. The unique situation that we have here does make clear that when you have a situation, as our courts have repeatedly recognized, where the effect of applying a technical regulation, in this case, the dormer being added to the second floor, would actually negate the vested statutory protection that the non-conforming use is afforded, that is a proper basis for a granting of the variance. And I cite those cases at page 4 of my material. Similarly, the variance with regard to the enclosure of the area where there are already existing mechanicals and the generator is supported by the fact of the cases I also cited, page 4, that hardship can be established based upon the existing non-conforming structures that are already located there. These structures are there. It's a positive thing for us, and not that it's proximate to our neighbors, but I suppose to our neighbors, to enclose in an aesthetically pleasing way these existing structures. So I think the hardship is established for that part of the application as well. So in summary, what we're asking you to do is totally consistent, I think, with statutory authority and case law. What we will do here by making a functional and aesthetic renovation to this cottage is maintain without intensifying the existing uses on the property, including the cottage itself, which will continue to have 2 bedrooms, no more, no less. Obviously, the enclosure is one that is a benefit to everyone concerned. It does not place any new utilities there. It only mitigates where they have existed for a long time. So we're very excited about the refurbishment of this wonderful piece of property. This is a step in that process. The cottage already has 2 stories. The dormer will provide both an attractive aesthetic, but also allow a nice functional reconfiguration of the kitchen and bath area. But at the end of the day, we're really not changing anything by this variance. I think they're technical in nature, and we'd be pleased to answer any questions you might have, but hope you will favorably consider our request. Thank you.
Thank you, Attorney Fallon. Any questions for Attorney Fallon? I know that Mr. Vicente and Tallman are also on the call as well, if you have questions for either of them. Any questions? Seeing no questions, is there anyone who wishes to speak in favor of the application? Hearing nothing, is anyone in opposition to the application? Hearing none there. Thank you, Attorney Fallon.
Thank you, members of the board.
Okay, the next item is number 8. 1859 Mill Plain Road, Petitioner Sproul and Jamie Braden for variance of zoning regulations, section 5.2.5, to increase lot coverage and total floor area from 10% and 20%, currently 19.7% and 37.6%, proposing 21% and 39%. Permission to construct a rear 1-story addition, premises AA zone. I think there's Braden on, Jamie Braden on the call.
Yes, I am, sir. Hello?
Yes, I can hear you. Oh, I was looking down on our screen. There's a Jamie Braden, but there's no.
Yes, my video is not working, unfortunately, but I'm speaking through my landline.
Okay, go ahead.
Good afternoon, Mr. Chairman and members of the board. Thank you so much for hearing our appeal. And Matt, I first want to thank you very much for walking me through and understanding the application process here. My husband, Sproul Braden, and we reside at 1859 Mill Plain Road, and we wish to construct a single-story 12 by 7, approximately 84 square foot mudroom, and relocate existing door from garage to the rear of proposed mudroom to existing patio. And to the members of the board, you should have copies of the survey and rear and side elevations, as well as the architectural plan, which includes the proposed mudroom. My appeal is based upon the change of my neighborhood from an A to a AA, creating really an undue hardship in reference to 8-6. Originally, our site here amongst the Duck Farm homes was Zone A, but has since changed to AA, thus making our home now non-conforming. If kept to the original zoning, this proposed addition should be conforming and legal. So this zoning change would now make any proposed addition illegal, really through no fault of ourselves as the homeowner. And now requiring us to go for this variance. The construction of the proposed mudroom shouldn't impair or adversely change the residential character of the surrounding area of these, colonial homes that neighbor us. And it really shouldn't negatively impact any property values of our neighbors. We are requesting just a coverage variance, which really shouldn't, cause a detrimental change to the character of the neighborhood. As residents, we're very sensitive to keeping and maintaining the appeal of the colonial homes along Duck Farm Estates. And
Ms. Braden, we lost you.
Hello, can you hear me now?
Yes.
Hello?
Yes, I can hear you.
Okay, thank you. Okay. So we really don't see this as a detrimental change to the character of the neighborhood. Again, as residents, we feel very fortunate to share such strong amicable relationships with our neighbors, and especially within the Riverfield surrounding community. You should have members of the board with you, copies of all signed letters of acknowledgement to the 4 direct neighbors, which includes my neighbor directly across the street, which are well aware of the planned 84 square foot mudroom that we have in mind. And, with that, we're sensitive to keeping this, beautiful appeal of these homes that have been built on Mill Plain Road, and we respectfully request that our variance be granted.
All right, thank you, Ms. Braden. Are there any questions for Ms. Braden? Just to recognize there are no questions because all heads are nodding no for the board. And anyone wish to speak in favor of the application? And is there anyone in opposition to this application? Okay, hearing none. Thank you, Ms. Braden.
Thank you.
Next item is number 9, 232 Harvester Road, map 49, parcel 21, petition of Urban Green Construction for a variance of the zoning regulations section 5.2.5 to increase the total lot coverage and total floor area from 15% and 30%, proposing 15.66% and 30.6%. Permission to legitimize a construction error, premises R3 zone.
Alessandro's the.
How you doing? I'm the applicant.
Yes. Yep, go ahead, Mr. Marini.
Can you all hear and see me?
Yeah, I can hear you, can't see you.
Oh. Anyway, good afternoon, Mr. Chairman and members of the board. Just wanted to give a recap of the project over at 232 Harvester Road. Originally we purchased property in 2017, and we submitted for a variance in January of 2018 for a front street line setback. It was granted, and we went in for a building permit, received our original building permit in March of 2018. As we were going to demolish the first and
Mr. Marini, we're kind of losing you, and I can. Oh, there. You're cutting in and out, sir.
Back for a demolition permit and to remove the entire. Hello? Can you hear me?
I don't think I can hear you.
Can you hear me?
You're cutting in and out.
You can't hear me?
I can hear you, but it's spotty. So.
Is it better now?
Yeah, there's like a little triangle in your box, which means that your connection is not good.
Wi-Fi, I'm not really.
Now there's no. So.
Hello?
Go ahead. Go ahead.
Is it better now?
Yeah, I can hear.
Okay. So we received an original variance and for minimum setback from the street line. Going to demolish the house, or we were going to build on the house, dug out for some contaminated soil. Contaminated soil was found to be underneath the foundation. Went back, had to get a demolition permit in order to remove the entire residence, the entire structure, in order to remove all of the contaminated soil underneath the foundation. We were granted the demolition permit and removed all the soil. We then went back for another building permit in December of 2018 that was not required. We were not required a variance for that. Built the house based on the drawings, kind of working with the original of, when we were using the existing foundation from when the house was purchased. The new drawings had a basement. We installed a basement because I already had the hole dug out for all the contaminated soil. Apparently, when we were working with the architect, the architect did not add in a Bilco door. Working together, we didn't have the Bilco door in there because it was never on the previous drawings. And the drawings are measurements from.
Mr. Marini? Mr. Marini, you dropped off if you can hear us.
Went on mute.
Matt, can you override his mute?
Trying. See if that works. Nope.
He should be able to hear us.
You should. Alessandro, you there? All right. Mr. Chairman, I could send him an email on the call-in line if you want to go on to the next one, if you think that's appropriate.
Yeah, we can do that, and then he can come in. We left off on the Bilco door.
Yep.
Bilco door issue, not being in the original plans and adding a Bilco door in. So
yeah.
I made a note of that.
I'll send him an email.
All right, see if you can do a call in, and we'll pick it up. We'll pick it up where we left off.
Oh, hold on.
Hello.
Are you back, Alessandro?
There's a new one. Yes, we can hear you now.
All right. I've been listening for the past couple hours with no issues.
Mr. Marini, you left off on talking about that the old drawings did not have a Bilco door, but the new drawings
Correct.
including the Bilco door.
Well,
So
the
pick
new
up,
drawings.
pick up from there.
No drawings included the Bilco door. With the architect, they were not included in the first drawings, the original drawings, but they did not. We failed to include them in the second drawings. So when the engineer did his for the survey, they were not included. And the foundation drawings mimicked the first floor drawings, where, you know, now looking back on it, the foundation drawings say tighter by touches on all sides in order to make up for the sheathing and the siding, which would stick out past the foundation. Taking all these into consideration, we added a step in the rear of the house, and with comes out to about 65 square feet of added coverage that we were over. So we're looking to get a variance just to make up for, obviously, these unfortunate miscalculations on our part. You know, with the building of the house is completed, and we have a pending sale. It is, you know, intention to make the house any larger, which over measurements and our miscalculations did not add to any interior square footage of the house. Didn't add to any, you know, larger rooms, make any larger rooms or any, you know, any in any way from the house.
All right. All right. Thank you, Mr. Marini. Any questions from the board for Mr. Marini? I see no questions. Anyone wish to speak in favor of this application? Is there anyone in opposition to this application? Having no one speak in favor or opposition, that matter is now closed. Thank you, Mr. Marini.
Thank you. I'm sorry about the connection issues.
That's okay. Number 10, 158 Reading Road, map 225, parcel 29, petitioner Michael O'Rourke for a variance of the zoning regulations, section 5.2.4 to reduce the sideline setback from 30 feet, currently 36.1 feet, proposing 20 feet. Permission to construct a one-story addition to existing garage. I think Mr. O'Rourke is on. Are you presenting,
Hello,
Mr. O'Rourke?
Yes, can you hear me?
Yes.
Okay. Thank you for your time and good afternoon. I'm hopefully gonna keep this short, but to simplify it, we're looking to add an addition to our garage, making it a one-car garage to a two-car garage. Due to the lot that we're currently on, it's technically a non-compliant lot. I think in the area, we're about half the size of the surrounding area. And due to this, there's not enough room based on the existing structure to extend. I think it's a 30-foot or 25-foot towards the edge of the property. So due to this, I'm here today to seek variance in terms of extending the existing garage.
And did you talk to the neighbors, Mr. O'Rourke?
So the neighbor that's like directly on that side of the property and closest to that said garage, they're the one that I have signature from. I have not heard back. What?
Kinney. Yeah.
Yes, Kinney, correct.
Yeah.
Yeah. So every other neighbor though, I've tried to reach out to and I've not heard from them, even since like moving into the property and trying to reach out on my own to introduce the neighborhood. So I have a good relationship with the neighbor next door and they're happily signed, and that's the amount of signatures I was able to get.
All right. Okay. Any questions for Mr. O'Rourke? Jane? Yes.
Hi, sorry. You have a barn on the property too? Do you store cars in there too?
No, we don't. It's more for like storage.
Okay. But you could put a car in there.
Yeah, we could.
Thank you.
Any other questions? All right, hearing no other questions, and anyone wish to speak in favor of the application? Is there anyone in opposition? All right, hearing none. Thank you, Mr. O'Rourke. That concludes number 10.
Thank you.
Number 11, 384 Sassapequan Road, map 74, parcel 361, petition of Lynn Hardigan and Michael Nicholas for a variance of the zoning regulations, section 5.2.4.3, to reduce the street line setback for an accessory structure from 30 feet, proposing 12 feet, and section 5.2.5 to increase lot coverage from 20%, currently 22.6%, proposing 23.7%, permission to construct an above-ground pool with an 8x10 deck and stairs, premises A zone. I've seen Ms. Hardigan. There you are. You have to if you're you're on the phone. Okay, go ahead. We can't hear you, Ms. Hardigan.
Does Matt have to?
Now I can hear you.
Can you hear me now?
Yep.
Okay. Thank you, everyone, for your time. My name is Lynn Hardigan. I live at 384 Sassapequan Road. The reason that we're requesting the variance is our backyard is very small and unusually shaped, and we couldn't fit a pool in the backyard, especially given the existing evergreen trees. Our side yard, we have recently fenced in, and it's an unusual shape. Also, our propane tank access is kind of centrally located in that side yard. Additionally, on the eastern side of the property, there's overhead wires that we wouldn't be able to put a pool under. So we're looking for a space to put the pool where it would fit, where it would be safe, and where it would still allow some yard space. We have 5 children, ages 5 to 14, and we want to, allow some yard space for them to play, especially since they're, given the circumstances, they're not using the community spaces in the neighborhood as we're social distancing to the extent that we normally would. There is a 6-foot privacy, white vinyl privacy fence enclosing the side yard right now, as well as about 14-foot tall evergreen trees lining the property line between our yard and the PRX yard. As far as the deck goes, there's a few reasons we're requesting a deck. One is I want to be able to have, be able to easily supervise my 5 children in the pool and have easy access to the pool while I'm supervising them. We have a close family member who doesn't live with us but visits often, who's a disabled 24-year-old, and the deck with stairs will allow her to access the pool. The deck will be gray composite decking, same as the existing porches on the house with white vinyl railings. We realized the house exceeded lot coverage when we purchased it. And we see that both the deck and the above ground pool as temporary. I realize that they're long-term, but, as our kids get older, the pool is going to come down, and of course the deck will come down with it. We have spoken to all of the abutting neighbors. There was no opposition. Everybody was happy to sign. I do have, if it's helpful, a picture that shows the yard is already fenced. The pool will not be visible from the street. It shows the propane tank access in the middle of the yard. And I think that is it in a nutshell.
All right. Thank you, Ms. Hardigan. Does anyone have any questions for Ms. Hardigan? Hearing no questions. Anyone wish to speak in favor of the application? Is there anyone in opposition to the application? All right. Thank you, Ms. Hardigan. That concludes number 11 and concludes the public hearing.
Thank you.
Okay, the board members, do we need a 5-minute break because you've been on and not been able to leave your computer, or can we go into our working session? We good? Raise your hand if you need to leave. Okay, all right. Okay. Great. Public hearing is now closed for July 9, 2020, and we're entering into executive working session. The first matter we have to discuss is the continued docket number 12. This is 101 Henderson Road, a petition of SUGS LLC. Attorney Fitzpatrick presented this, and it's to confirm a legal status of a vacant piece of land as a building lot. We heard from Attorney Markley, and we had submissions on that relative to opposition. There was a condition proposed and so I'd entertain a motion to approve the condition that any structure on this would comply to all zoning regulations and no further variances would be requested. With that condition on it, I'll entertain a motion to approve. And whoever's going to move, please just state your name and say, I move.
Jane moves to approve.
Thank you, Jane. And second, whoever's going to second, just state your name and say, I second.
Faith, second.
Who?
Faith, second.
Faith. Okay, discussion.
I asked the question about the term vacant land on the assessor's card. And Kevin, maybe you can explain that. That's not a legal term? That just is what somebody decided to type in that day?
Well, it's on vision appraisal, I think. And it's
Or
not
whatever
on
it is.
the,
Yes, exactly, on vision appraisal.
And
So
vision appraisal is just people that do drive-by appraisals. I don't think their information might be good as a collection of some data, some amounts and deed numbers, but I don't think vision appraisal can say and quantify. Whatever they say doesn't affect us.
Okay, so
one way or the other.
So then if there is another place in Fairfield, an actual acceptable building lot, would that same would it say building lot in that same chart or that same form on another
From
property?
vision appraisal, I do not know that. I don't know that, but
So it doesn't. So
they're
it's sort of a
gonna say, well,
meaningless term. It's
correct. It's vision. It's a company that does this by computer, and I don't even know if they drive by. Most of the time, when you look on vision appraisal, they don't even have a picture of the house.
So the distinction between a building lot and vacant land is irrelevant, according to vision appraisal, or what
Vision
we're talking
appraisal,
about.
I can't speak for vision appraisal, but I would not put any legal significance to vision appraisal. If they said building lot, we wouldn't be conformed to that.
Okay. All right. Thank you for that.
Any other discussion? I mean, I'm looking at this and I have to say, you had two lots back in 1922 and they were purchased separately. And that was to me, that was the strongest point that Attorney Fitzpatrick made is you had the house already on the one, and then later they bought the second lot.
Right.
So 2 years later, it wasn't like it was a quick. Yeah, and the people, I think the Carroll family, it might be the same family, they owned where the people that opposed at one point. It looks like they were buying lots for building. So it seems to me that this is reasonable, especially in the neighborhood. When you drive up and down that street, you notice a hole, and
it's like the missing tooth.
I understand Attorney Markley's position. I can sympathize with the people that are next door, but I think it does qualify for a hardship based upon the changing in that zone. Well, adopting zoning regulations, not alone the changing, but adopting them.
Mm-hmm.
Any other discussion? All right. We can vote. Jane?
Jane says yes.
Terry?
Terry Keegan says yes.
Katie?
Leo Grady says yes.
And Faith?
Faith says yes.
And Chairman says yes. That's 5 that has been granted. Number 1, 41 Alden Street. It's petition of the Grunbaums. Mr. Clark presented that, and it is for installing an in-ground pool. Entertain a motion to approve.
Motion to approve. Katie.
Katie?
Jane seconds.
Okay, discussion?
So the condition of moving the pool equipment, is that going to be part of this application?
Well, are you proposing an amendment to the motion?
Yes. Yes,
Okay.
I'm proposing an amendment to the motion so that the pool equipment is moved alongside the generator.
Okay. Is there a second to that request for amendments?
Jerry Keegan seconds.
Okay, discussion on that?
I think it will address the neighbor's concern about noise and interference in her property.
Okay.
Isn't it still on her side? Wouldn't it still be on her side of the property?
But it's farther from the side of her house. It's many feet farther away. Yeah.
Legitimate request, right?
Yeah.
Yeah, it's a,
Oh.
it's on the safe side, Katie, but if it alleviates it, and then, and it was offered by the applicant. All in favor of the amendment to that condition? Just raise your hand. I have all hands being raised. So the motion now is to approve this application with the condition to move the pool equipment to the area of the generator. And that has been seconded, and we're ready to discuss that. Okay? Any discussion on that? We already hit it on discussing the amendment.
I think everybody, will walk away happy after that.
Yeah. Can I say anything?
No, you can't, Mr. Clark.
Okay,
yeah.
Sorry.
I said that early in the, this is time for us to speak only. All right. You can talk, Faith.
He referenced that he couldn't make it less than 10 feet wide, but I'm wondering why he didn't consider making it less than 31, just to make it a little, at least to get one side in, to be, I mean, it actually is a large pool. I've had a pool, I've been a swimmer all my life. Pretty long.
Is there a standard lap length that's not Olympic? I mean, just for like high schoolers, what's a lap length?
Yeah, well, that you're not going to get. That's Olympic size.
Yeah,
What's the next?
We're not going to have that.
What's the next smaller standard, or what's the smallest standard in length?
I don't think there is a standard.
Yeah.
No, there's no standard, I don't think. The only thing I've seen are the automated lap pools where the current, and you have to go against the current.
Right. Those could be.
Those only need to be about 12.
Exactly.
Feet long,
Exactly.
But that's not here. That's a little different.
It's basically when you get to the end, you turn around.
Right.
Yeah.
Well, the neighbors that are directly affected by the location of the pool don't seem to mind it.
I don't think they mind it because it is really so well screened.
Right.
In this area.
Right.
And it's only going to get better.
It's not the size. It's nobody can predict what the noise will be when there's a party, but maybe they'll be invited and it won't matter.
Yeah. Okay. Bring it to a vote. Jane?
Jane says yes.
Terry?
Terry Keegan says yes.
Katie?
Katie O'Grady says yes.
Faith?
Faith, no.
I say yes. For the one that has passed. Number 2, 1391 Black Rock Turnpike, lot number 1. Petition by Lucas Papa George. This to establish a building lot for the single family home that is there. And entertain a motion to approve.
So moved, Terry Keegan.
Thank you, Terry. Is there a second?
Faith, second.
Okay, great. Let's discuss this.
There's
This
a
is
lot.
where the existing, this is where the existing house is. I mean, obviously, we keep in mind that we're going to be discussing the other one as well, but we have to vote on them separately, obviously. So our discussion may be somewhat overlapping for both of those, but what are your thoughts about this? I mean,
Can I go first?
Yep.
As the architect in the group, there's not enough information here really to evaluate this. We know it's an old house, and I appreciate that they want to keep the old house, but they're showing kind of a dotted line of a proposed addition that's not really designed, and it kind of eats up a half the house, and the driveway's kind of not really figured out. So I don't think there's enough information here to evaluate it.
Oh, yeah, that was good questions. There's not, I mean, whether they can actually place that curb cut over on that other road, which it does make a lot of sense. What they, plan to do with this house. But
How about Ozawa Hall? Doesn't that actually be behind the stage Ozawa?
part of it, the way I'm looking at this is they want to see if they're going to get this variance before, because they're either going to design, something totally different and use the larger piece of property, or, it's over 10,000. No, not over 10,000, but 9,000 square feet of property. Whether they're going to be able to have two homes, or whether they're going to try to make that existing home bigger, or whether they're going to try to do something else in the form of some type of a two-family.
I don't think it's only two choices. I think there's a third choice, which is to do a really nice addition to this existing 120-year-old house and keep the property.
Yeah, that's what I said in the beginning, in the middle there. Yeah.
Right. So it's not. Yeah. Okay. So, but we
Not
don't
either
have
or,
all the information. Yeah. No, but the way it was proposed was either they're going to build two lots, get the second lot and build a new house, or they're going to knock everything down and build a two-family house. But there's that third option that we just described as well.
It's a third option, practically, and maybe we could ask the real estate agents on the call. I don't think a large home in that area would sell.
Agreed.
Agreed. Right.
But a two-family could.
Agreed.
Agreed.
Yeah.
So, I mean, I'm, been on the board a long time, and I'm looking at this, and, and I think Mr. Papa George, I think he understands, and I know he's still listening, which is great. But coming back to us to build an addition, I don't think he's going to be asking for any variances based upon your concerns that it was a little bit incomplete at this point.
But isn't it all part of the same application?
No. If he's tearing this down and he does, the only thing we're deciding is whether this can be, this area that's on the maps can be a lot. It happens to have a house on it. The house needs to comply. He's not asking for any variances for that existing structure.
But
he's only asking for this to be a lot of
right. But part of the
4,600.
application is showing new work on this house. So isn't that just part of the application?
He doesn't have a variance for that. So if he builds right there and it doesn't comply with zoning, he's
right. I just think this is an opportunity. I mean, zoning is design, and here's an opportunity to not say no, deny this and don't come back, but to deny it and say, come back with more information. What is this going to look like? What's the new house going to look like?
Excuse me, can I clarify this? If he decides that renovation is not within compliance of zoning, he has to come back for a variance again, correct?
Yeah.
So
he's not seeking any variance. He's not seeking any variance for the existing house. The only variance he's seeking is to have the lot size of this lot at a size of 4,659 square feet and a square of 55.02 feet. So if he doesn't comply with that square and any other zoning regulations for this new lot, if it's approved, he has to seek a variance, right, Matt?
That would be correct.
I didn't have to ask Matt, but I want a little backup on that, just to
Yeah.
make sure.
But did he not also say that as a condition, whatever the new house will be, he will not come back and ask for a variance, so it will be compliant?
When we were talking about the complete new lot with nothing on it,
Right.
he offered that condition. But, I mean, for stuff like that, in my opinion, it doesn't necessarily need to be a condition because he's not getting any variances for that. I mean, he'd have to come back to this board with this history of
right,
and seek a variance. And he'd have to have a really good reason. I can't think of one right now.
Yeah.
Sorry. I'm not as worried about that, Jane.
Yeah.
I'm looking at just he wants to establish 2 lots with this piece of property.
Right.
And that's the only variance that we're looking at. He's telling us what he wanted, the overall plan, which we want to hear, is that he wants to try to keep that house. But as Faith said, if he can't,
right,
he's going to have to build a new one.
Right.
Big one. And it would make sense to sell that, it would make sense for him to do his best to make an entrance on the side street.
Right.
I wouldn't want my 17-year-old daughter pulling out on Black Rock.
Right. I just wish there was more figured out.
Well, I can understand why he wouldn't have architectural drawings. They don't come free. And for him to have them and then us to say no to dividing the lot, he now has to go get another set of architectural drawings.
Right. Well, at the very least, check with engineering about putting the driveway on the corner. I mean, I hope it works. Because, yeah, it's a safety issue, but I just...
Discussion?
No.
Okay, so this is on number 2, okay, which is the house, the lot that already has a structure mostly on it. Jane, your vote?
I'm going to have to say yes because it's a zoning question, not an architectural design question. So, yes.
Terry, yeah. Katie?
Yes.
Faith?
Faith, yes.
I'm yes. Okay, thank you. Number 3, 1391 Black Rock Turnpike, lot number 2. Petition of Mr. Papa George. Now, on this one, Jane, he did offer the condition. Now, this is belt and suspenders approach. I don't necessarily think we need it, but I will entertain a motion to approve this, that any new structure will conform to all zoning regulations. He will not seek a variance. With that condition, entertain a motion to approve as to this new blanket blind lot.
So moved, Terry Deegan.
Jane seconds that.
Okay. Thank you, Terry. Jane? All right, discussion?
I just think it's sort of good faith to the neighbors that, he's not going to try and shoehorn in some gigantic monstrosity. He's happy.
He said, I'm getting a little feedback that, the neighbors like. Any other discussion?
Faith, I think that's kind of tying him into something that he can't protect. And at what point, any future additions does that hold down?
Well, he offered the condition.
I would like him to aim for it, but I wouldn't want to tie his hands. He has to come back to us anyway.
Right.
So we could just say no then.
Right. But if he offered that as a condition, don't we just take it on face value?
As I say, I look at it as a belt and suspenders. It's, you know, if he's maybe he's gonna work a little harder to get it, to fit it in than if he didn't have the condition. That's.
Yeah. I mean, design it once, design it right.
All right, Jane?
Yes, with that condition. Yeah.
Yeah, Terry says yes.
Katie?
Yes.
Faith?
No.
I say yes. Number 4, 12 Brookdale Road. Mr. Wolkonovitz presented his application. It's to construct second floor addition with attic over existing first floor. Entertain a motion to approve.
Motion to approve.
Who was that?
Katie.
I thought so. Okay,
Me.
thanks, Katie. Is there a second?
Jane seconds.
Thank you, Jane. Discussion? Straight up for the existing, and the house was built 6 inches too close.
Yeah, this is a slam dunk, I think.
Yeah. All right. Jane, your vote?
Jane says yes.
Terry?
Terry says yes.
Katie?
Yes.
Faith?
Faith, yes.
What'd you say, Faith?
Yes.
Okay, and I'm yes. 5, that's been approved. Number 5, 207 Main Street. It's petition McGrath and Las Paludo, and Mr. Dumke presented this for them. It's to construct a dormer. Entertain a motion to approve.
So moved.
Thank you, Terry. Is there a second? Who's it, Katie?
Faith.
I'm looking for the blue highlighter on your face, and that's how I can tell who says it, unless you say your name. And I didn't see it, so when I'm looking down. All right, discussion?
Does this go through historic? And I should know that.
Yes, it does.
Yeah.
Yes,
okay.
in fact, Mr. Dumke was hoping we could get finished in time and hopefully approved, so he could
That's right.
mention it to them.
I apologize. You're right.
And they're asking for 0.1 over what they already have, correct?
Right.
Yes.
I'm familiar with his work. He just did something for a client of mine around the corner. What he does is fabulous, but just for the sake of argument. So.
Yeah, and it's to the back little corner garage. It's not even on the main structure. So hopefully a historic commission feels the same way, but you never know. Jane?
Jane says yes.
Terry?
Terry says yes.
Katie?
He says yes.
Faith says yes.
I say yes. That's 5 in favor. That's been approved. Number 6, 257 Roland Road, petition of the O'Connors. It's to construct a rear deck. Entertain a motion to approve.
Motion to approve by Katie O'Grady.
Second.
Second. Terry,
thank you. Discussion?
It doesn't add any more impermeable area, so that's a good thing.
Yeah, and it's, it's taking up over where we had the patio anyway. Deck is probably a little more usable than patio. So. All right, Jane?
Jane says yes.
Terry?
Terry says yes.
Katie?
Katie says yes.
Faith says yes.
I say yes. That's been granted. Number 7, 1514 Hillside Road. Petition of Ms. Attorney Fallon presented this. It's to second floor addition, a dormer, and enclosure of a generator. Entertain a motion to approve.
So moved, Terry Keegan.
Thank you, Terry. Is there a second?
Second, Katie O'Grady.
I can't get your second if you're muted, Jane.
Muted?
So I have Katie as seconding that. Discussion? Any discussion?
It's a good way of repairing and getting what they need. It doesn't affect anybody but the homeowners.
Just Mr. Ravis to the side.
And they said fine.
If he can see it. All right, bring it to a vote. Jane?
Jane says yes.
Terry?
Terry says yes.
Katie?
Katie says yes.
Faith?
Faith says yes.
I say yes. That's approved. Number 8, 1859 Mill Plain Road. Petition of Braden's to construct a rear one-story addition. And Ms. Braden presented the application. Entertain a motion to approve.
Move to.
Jane, is there a second?
Faith seconds.
Thank you, Faith. Discussion. I mean, changing the zoning requirements to that, all those homes that were built in there is a tough one for them.
Right. We've done this
All
for
right.
some of the other neighbors there too. Similar things.
All right, Jane?
Jane says yes.
Terry?
Terry Keegan says yes.
Katie?
He says yes.
Faith?
Faith says yes.
All right, and I say yes. Thank you. That's been granted. Number 9, 232 Harvester Road. Petition of Urban Green Construction. Mr. Marini presented this. It's to legitimize construction error as to lot coverage and floor area. Entertain a motion to approve.
I move to approve.
Jane, is there a second?
Faith seconds.
Thank you, Faith. Discussion?
This was truly an error. It wasn't, something underhanded. So I think it's pretty straightforward.
Yeah, I mean, they were there a long time. I'm not too far from I walk my dog past there. So they were stuck there a long time, digging out and.
It's very small what they're asking for.
Yeah.
Less than 1%.
What's your vote, Jane?
Jane says yes.
Okay, Terry?
Terry says yes.
Katie?
Yes.
Faith?
Yes.
I say yes. That's approved. Number 10, 158 Reading Road, petition Mr. O'Rourke. He presented it. It's to addition to his existing garage. Entertain a motion to approve.
Faith so moved.
Thank you, Faith. Is there a second?
Jane seconds.
Thank you, Jane. Discussion?
I have. Oh, that's. You want to go first, Jane?
I just want to say that the next door neighbor that's directly affected by this, they have no approval from. So I don't know if that means they couldn't contact them or whether they didn't like the answer that they got or what?
Jane, they do.
They do have that?
over to you.
Oh, that came late then.
emailed that
Okay.
over to
All right. I
everybody, yeah.
apologize then.
That's okay. I just want to, it was late today, so I just want. I
Okay.
wasn't sure we
I'll
got
double
it.
check. I'll double check. Yeah. It's
It's a AAA zone. I mean,
right.
there's space.
Well, that's the other thing, though. I mean, this is it's still a huge lot. There's plenty of other places to put garages and things, but they want it attached. So
You want a detached garage?
they have a whole barn.
Yeah, but the barn's on the other side.
Right. I'm just saying that there are alternatives.
Yeah, but I think you want your garage.
Right.
If you're going to have a 2-car garage, you want both cars next to each other.
Yeah.
Yeah, and it I know this property well. I drive by it more than once a day, and it would look, the addition would look like it was always there. What doesn't, it would be what, there's no issues aesthetically on this. I know that's not our charge, but.
Right.
It would look odd to put it in another place.
All right, well, let's vote. Jane?
Jane says yes.
Terry says yes.
Jane, what's your vote?
I said, Jane says yes.
Oh, I didn't hear you. I'm sorry. Terry?
Yeah, Terry Keegan says yes.
Katie?
He says yes.
Faith?
Faith says yes.
I say yes. That passes. Number 11, 384 Paspequan Road. Ms. Hardigan, for her and Mr. Nicholas, she presented the applications to construct an above-ground pool with deck. Entertain a motion to approve.
Motion to approve.
Faith moved. Is there a second?
Second, Terry.
Terry. Discussion?
I think I consider an above ground pool an appliance that can go away. It's not a permanent.
The Arvo,
so
they
it's
are a
easy.
little bit more temporary than.
Yeah.
Yes.
Yeah. So that's fine.
I mean, I'm glad that the fence is there. If the fence wasn't, the privacy fence wasn't there, I'd be concerned because it's a corner lot and it's a weird corner. It'd almost be like it was in their front yard, but
Well,
since
you
that
have to,
fence is
right.
there, it's good.
But you need a fence anyway for a pool. So
Yeah, but you don't need a fence that's blocking fence. You could just have a rails, so not a privacy fence. You don't need that for the pool. So, all right, Jane?
Jane says yes.
Terry?
Terry says yes.
Katie?
He says yes.
Faith?
Faith says yes.
I say yes. That concludes this. We'll wait and have to see what next month brings us. Thank you, everyone. Thanks, Matt, as always.
You're welcome.
Take care. Thanks, Josephine.
Bye.
Is that deck outside your office?
Goodbye.
Somebody talking to me?
No, I was talking to Kevin.
I came back in. I was muted. I don't know. Bye, guys. Good seeing you all. Bye.
Bye.
Bye.